I'd like to welcome everybody, whether you're live or you view this webinar at a later date. Welcome. It's a dreary Thursday afternoon, but fortunately we're all dry. My name is Matt Cruz. Joining me is Oscarsson and Sarah Smith, other members of the planning and administration group here at Beresford Booth. We're here today to discuss or present another installment in our estate administration series. If you haven't joined us before or are not aware, you can find links to our previous presentations through our website. We have discussed a variety of topics, including community property and estate planning. Do I need a will or a trust at all? What happens if I should die without a will or a trust? And we're presently in a little bit more focused series regarding estate administration. We've talked about the basic process. First, to determine who's in charge of the estate administration. Secondly, the need to gather the estate assets. Thirdly, pay the bills. And today we're going to talk about distribution issues. So if you have interest or questions about any of the topics I've just mentioned, again, you can view our prior presentations through a link on our website. Per and Sarah, when we are assisting in an administration and we get to the distribution phase, how do you approach that? What are some of the things that you guys think are important at that phase of the administration process to consider? Either one of you.
Well, one of the things that I think about, and hopefully we thought about it much earlier in the process, is do we have a solvent estate or an insolvent estate? Because that's going to make a big difference.
Mm-hmm.
Another thing is, do we have community property? Do we have separate property, which will make a difference if we have an intestate estate or estate where there is no will, because under those circumstances, the state law provides at least the fractions that will be shared among those who will share in it. So we may need to be very careful in looking at all of that. But hopefully, again, that's not as we're getting toward the distribution, but hopefully much earlier in the process.
Here, let's back up to the solvency question. When it comes to just pure distribution issues, what is important to understand about the solvency of the estate? How does that impact, whether the estate is solvent or not? How does that impact distribution?
Well, generally, if it's a solvent estate, and assuming that the personal representative has non-intervention powers, they can pretty much just follow the will or the trust, as the case may be, in making distributions of assets, assuming that there are sufficient assets that have already covered any debts that were to be paid out of the estate. Because if the debts are greater than even the specific bequests, there could be some distribution issues that arise because those debts have to be taken care of first. And so wanting to make sure that we've got a solvent estate, again, I think we are, I don't want to say free to do as we please, because the personal representative is bound by what the will says. But as long as they're following the will and we have a solvent estate, they should be fine.
So remind us, maybe there's some people that aren't very familiar with these concepts. What does it mean to have a solvent or an insolvent estate?
A solvent, and it's a very simple test, kind of what they think of as a balance sheet test. Does the property owned by the decedent, does the value of that property exceed the debts of the decedent? And it's just, is asset greater than liability? If so, you've got a solvent estate. It may not be solvent by much, but it's still solvent. If those two are reversed so that the liabilities exceed the assets, now you have an insolvent estate, and that will affect things as well, because if it's insolvent, there will be no distributions to the beneficiaries, and there may not be full distribution or full payment to the creditors.
Yeah, you mentioned this issue of solvency doesn't just arise for the first time when we get ready to make distributions. This is one of those issues that we have to focus on and determine right from the outset. Isn't that right?
That's right. When we file a petition to open an estate administration, whether testate or intestate, we need to provide to the court information, and it's not specific, down to the penny, but we need to provide information that says that yes, this is a solvent estate, because generally the personal representative will receive non-intervention powers if it's a solvent estate. But if it's an insolvent estate, again, whether testate or intestate, then non-intervention powers very often will not be granted, and that certainly changes how the personal representative approaches what they do. So from the very outset, we do need to have at least a rough estimate that we have a solvent estate.
Yeah. And let's just go one more level down. How does it change from an administration standpoint if we know at the outset that the estate is insolvent? How does the court react in that situation when we're opening an estate?
Well, very often there'll be a bond required of the personal representative that might not otherwise be required, because now the personal representative will be focused on making sure that the creditors get paid. I mean, that's one of the focuses when we have a solvent estate, but in an insolvent estate, it's going to be the creditors that receive, and the court will want to make sure that the personal representative is dealing with those creditors properly. So may require a bond, most likely would require a bond, and it will be necessary for the personal representative to get court approval to do most things in the administration. That's the difference between the non-intervention and the intervention powers. With the intervention, you've got to go get permission from the court to either pay the creditors or potentially, if it turns out that, oh, you did find some solvency there after all, that any heirs might receive something.
Yeah. So the concept of non-intervention powers refers to non-court intervention in the administrative process largely.
Yes.
And usually non-intervention, non-court intervention powers are granted when the estate is solvent. There can be some exceptions on special issues, but that generally is the key test for whether the court will grant the personal representative non-intervention powers. And the benefit of non-intervention powers is it's a great cost savings generally. You're not having to seek court approval to pay bills or secure assets or make other administrative decisions. But that doesn't mean the personal representative can do whatever they want to, because at the closing phase of the estate, there's a report that has to be made to the court and to the financially interested parties. Everybody basically has to approve that report before the estate can close. So it's not a situation where if non-intervention powers are granted, that means there's no accountability, is the point that I'm making.
Right.
Okay. All right. Good. Yeah. Good thoughts. So the other thing I think that you've stated is if the estate is insolvent, meaning the debts or liabilities exceed the value of the assets, it's important to note, may seem obvious, but it's important to note that all of the estate assets will then be used to pay debts of the estate of one kind or another, including the cost of administration. If you hire a lawyer, those costs get paid first. Last, illness and funeral expenses enjoy priority payment, as do personal representative fees. So those all get paid first, which further increase the insolvency of the estate. Now, if let's say there are 5 creditors and the estate is insolvent, how do you figure out who gets what? Sarah, do you have any thoughts on that?
So the codes have rules that you can look to. But quite honestly, some of the things that you might think about are, reaching out to the creditors, seeing if they're willing to negotiate on the amounts that are due so that you can provide enough to pay for everyone. It really depends on the circumstances of the situation.
Yeah. So if we have an insolvent estate where the assets are not enough to fully pay the creditors, that first of all, it means the creditors are going to get less than all they're owed. They're going to have to accept some compromise. So generally what we do is, as Sarah mentions, we'll go through a phase where we try to negotiate the balances owing to each creditor. Often creditors will negotiate a bit. They know that they're going to get some pro rata percentage of their debt as related to the other debt facing the estate. So our initial calculation is to determine the amounts owing to the various creditors. And usually we're talking about unsecured creditors. Secured creditors, the home lenders and the car lenders, et cetera, they have security to try to execute upon in one way or another to satisfy their debt. And they're not entitled, if they should foreclose, they're not entitled to be paid more than what they're owed. So really what we're talking about is dealing with unsecured creditors, credit card companies, gas cards, Visa, Amex, et cetera. So we know when there's an insolvent estate that the unsecured creditors are not going to be fully paid. So we first determine what they're owed. We calculate what the individual debt is as a percentage of the total debt the estate is facing. And that gives us a pro rata percentage of all the unsecured creditors. And then, as Sarah was mentioning, our next phase typically is to go to each of the creditors. Oftentimes we have to provide a debt schedule to reflect all the debt owing against the estate. And we attempt to negotiate reductions in the amounts owing. Sometimes we can successfully negotiate back into a state of solvency. Often we can't, but sometimes we can, depending on the circumstances. So each of the unsecured creditors is going to get either a straight pro rata share of the overall unsecured debt the estate is facing, or some lesser amount based on negotiations. And if after the negotiations, all the creditors are paid and there's a little bit of money left over for whatever the reason, it's that money that is available to distribute according to the instructions provided by the will or by the trust, or if no will or trust, by state law. Okay. Let's talk a little bit about another issue that comes up. We're focused now on a solvent estate. The debts have all been paid and we've got money to follow the distributive plan in the will, the trust, or by law. How do we figure out the order of distribution of the remaining estate assets? Per, do you have any thoughts about that?
Sure. Washington has a provision in law that allows for a separate writing that deals with certain types of tangible personal property. Tangible being what you can put your hands on. Now, there are certain things that, although you can put your hands on them, they don't qualify as tangible personal property. Paper money is probably a really good example. A stock certificate, Microsoft stock or whatever stock, it's a security. It's represented by that certificate, but it's an intangible. So I think practically every will that I have ever seen, and some trusts, make reference to the fact that there might be this separate writing. And if that's the case, and if there is a writing, then those are the things that should be distributed first. And it may not deal with all tangible personal property in an estate or a trust. It may just deal with some. There may be a favorite piece of art or a favorite piece of jewelry, or I know that my car has to go to a certain person and I put it in a writing. Those things have to get done first. If it's not on the list, then it typically would then fall into the residue of the estate and gets dealt with there. But that would be the first thing is find out first of all, does the will or the trust actually make reference to a writing which may or may not have existed at the time that the document was, that the will or the trust was signed? And if it makes reference, is there such a writing? And that may be difficult to find, because the writing, it may not be entirely clear that it was intended as such a writing. The statute's pretty, I would say, pretty vague on what constitutes a writing. It could be a nice list that's clear as this is the list that I meant when I put that in my will. Or it could even be something that's in a letter. That has a possibility as well. So checking to see if there is the reference, because if there's no reference in the will or the trust to some sort of a separate writing, even if that writing exists, there's a problem. That writing is not going to be held as being valid. So is there the reference to a writing, and does such a writing exist?
So when you're talking about a writing, you're talking about something separate than the will or the trust, right?
Something separate from the will or the trust. A
Okay.
completely separate document. I mean, it could be something as simple as, doing it on a yellow pad, and dating and signing it. It may be that simple.
There's a statute that governs the elements of this writing, correct?
That's right.
Yeah, so as long as the writing meets those elements, it's potentially enforceable. I say potentially only because if the writing purported to give U.S. tender or other form of non-tangible personal property, it could be invalid because that's not what the statute says the writing can be used for.
That's right.
Yeah.
And
So
it
there
can
could
be
be a
kind of
couple of
confusing.
questions.
It can be kind of confusing because your example of tender, legal tender, if it's coins, like you have silver or gold bullion, it can be in the form of coins. If those coins can be used to purchase something, they can't go on the list. But if they're a type of coin that could not be used in a store to purchase something, they're probably acceptable on the list.
Yeah.
And so it's kind of well, maybe yes, maybe no, but you got to look at the specific circumstances.
Sure. So after the list provision, how does the order of distribution generally flow?
Generally to the specific bequests, if there are any. I have seen wills where it makes reference to a separate writing, and if it's not in writing, everything else goes in the residue of the estate and gets distributed however that provides. But there could be specific bequests, and those would come before any distribution of a residue.
Yeah. So is there any limitation like there is with the list provision on what can be given in the specific bequest section of the instrument?
Not really. There are some things. We have a super will provision that allows for dealing with some non-probate assets, but you can provide in the will under the right circumstances that despite what you may have had in that non-probate asset, for example, where you had a beneficiary designation, the will may provide, I want to do it this way, not the way it was set up. But you have to look at the timing of when was that other asset created, how was it created, and in relation to when the will was signed. So there may be some things that like that may or may not be governed by the will, but pretty much everything else could be governed by the will, whether specifically or just by lack of reference to it. It falls into the estate, maybe it falls into the residue, but the will doesn't specifically say what it is, which is not unusual because the will could be many, many years old, and the deceased may have acquired significant property, whether it be real estate or personal property, after the execution of the will, and never revised their will to specify any of it.
Right. So the way I've always looked at this is a good general rule is that we're always trying to enforce the decedent's latest expression of testamentary intent. So sometimes that's in the will, sometimes it's in a later account that was created after the will.
Mm-hmm.
And so there can be some confusing things, but the place to start in terms of figuring out how to resolve distribution conflicts or conflicting instruction or source of instruction is to start with the idea that we're trying to enforce the decedent's most recent expression of testamentary intent, whether that's a pay on death designation, whether it's a form of joint ownership, whether it's something in the will or in the tangible personal property list, the specific bequest section, or the residuary that might conflict or might not conflict with a super will provision. So the general rule is we're always trying to figure out what the testamentary intent that's enforceable is. And as a general rule, it's the most recent expression.
Right.
With a whole bunch of exceptions, frankly.
Of course, you have to have the exceptions.
Okay. I see we're getting a little bit toward the end of our time here. You know, what about a couple of things I want to talk about? What happens when there's not a specific bequest to give away the dining room furniture, the table and the chairs? It might have some economic value, but may have more sentimental value. And let's say all three of the heirs want it. Any thoughts on how we might resolve conflicting interests in a particular thing?
Well, if the heirs can all manage to agree, then this is where, if the personal representative has been given these non-intervention powers and there's nothing to the contrary in the controlling document, they may be empowered to decide who is going to receive the specific property when there cannot be an agreement. If there is an agreement, then you can go according to that. You know, ideally with these smaller assets, you don't want to have to go through all the trouble of a larger argument or an appraisal or what have you for something that may not have as much value.
Sure.
I've also seen where the will or the trust has a provision for how to deal with it. Even as simple as we're going to start with let's just take it as children. There are 3 children. The oldest child gets the first pick. They get to pick whatever they want out of it. Next child gets the next pick. The youngest gets the next pick. But maybe it reverses for round 2. The youngest now gets to pick. So now they've got picks 3 and 4. Now the middle child gets picks 2 and 5. And they just keep doing that until they've reached the end. So they don't really have agreement as such, because the deceased has provided, hey, if you can't agree, this is what you're going to do.
Yeah. Yeah.
And there could be any variety of those types of
right.
methods.
So Sarah, I agree. We want to try to reach agreement if we can, and we work hard to do that, to solve a conflicting distribution interest like that. Per, I agree with you as well. We obviously we're bound by the decedent's expression of intent. If the decedent in the planning, the will or the trust was thoughtful enough to include some kind of mechanism for resolving conflicting or competing interests, then we certainly need to follow that. I've dealt with many situations where there is no such instruction and agreement cannot be reached. So one of the methods that I like to use, I found it to be fairly effective, is amongst the 3 competing interests, for example, we'll just ask them to submit bids. And it's exactly as the process sounds. We just keep going until we achieve, with the bidding process, until we achieve the highest bidder. Going into the process, I always explain that this is like a real bid. You're bidding with real dollars. So be mindful of that. This isn't funny money or monopoly, because the prevailing bidder will not only get the item, but the prevailing bid will count against the rest of their distributive share, so that they in effect purchase the item with a portion of their inheritance as they're going through the bidding process. So normally, you know, not everybody is willing to bid their an unlimited amount of money. So typically we have a winner. Never have I had a situation where the bid exceeded the value of the party's inheritance, but that's possible. And when the prevailing bid exceeds the value of the party's inheritance, they'll need to understand, that means they have to write a check out of their personal estate to make up the difference. So I call this just a bidding resolution to determine when people will, how much the item or items mean to them. They know that the prevailing bid will count against their inheritance, and they know that if they're willing to bid more than their inheritance, they'll have to come up with money to make up that difference. So there are a lot of methods, as Per suggested, to try to resolve it. This is an effective way that I've found to resolve competing interests. Well, I do see that we're running out of time here. There are many other issues that come up at the level of distribution. Do we have anybody who would like to ask a question? Sarah, has anybody presented a question?
One, it says, a family friend would like me to oversee closing her $200,000 to $500,000 estate. How much of a burden in terms of time would it be to me to close down all of her accounts and dispose of all of her belongings and pay her debts? And more importantly, how much can I offload onto the attorney I hire?
I'm sorry, what was the last part? How much can they do what?
How much of the work can I offload onto the attorney that I hire?
Oh, okay. Well, I'm happy to respond. And Per or Sarah, feel free to jump in. First of all, with regard to how much of the work you can offload to the attorney, the way we approach it is we're happy to do as much or as little as you'd like us to do. We're your lawyer, and the division of labor certainly will guide you. We'll be prepared to assist with not only advice, but forms and procedural advice and requirements that you must comply with. But in my view, how much or how little the work is really something to be settled between the lawyer and the client regarding the process, with heavy weight given to the lawyer to inform the client of what the process is and where the lawyer could be most useful, et cetera. So there also are practical considerations. You know, we're hired on an hourly rate basis. So it doesn't make a lot of sense to hire us at our lawyer rates to go clean out the house, typically. It would be much more efficient, even if the representative didn't want to do that work themselves. There are a lot of other alternatives. We can hire people to go do that for us. You know, there are companies that will help clean, repair, you know, otherwise prepare a property for distribution or sale. So the work is available for hire. Not everything will it make sense to hire us to do, and where it doesn't make sense, we'll advise you in other ways to allocate the various work that needs to be done.
And Matt, if I could just pipe in just a little bit, yeah. I think part of how much the attorney gets involved will also depend upon the nature of the assets and what it takes to transfer them, because sometimes those can be very complicated processes. For some assets, it won't be, but for some assets, it very well could be. I know a few years ago, transferring securities was to put it nicely, it was a big headache. And I think it might have become more of a headache because some of what we needed to do with banks, and a lot of banks are not providing that service that they used to provide, even to their own customers. So I think that, again, I think it depends upon the nature of the asset that's being transferred. And it may also depend upon, are we talking about multiple people sharing that asset, or is it just going to one distributee?
Yeah, yeah. So the allocation of the scope of work and the relative cost, those are all fair issues to clearly work out with your estate lawyer at the beginning of the process. And you can expect to revisit the cost benefit of having legal service perform each of the function as you go along. We're always very careful to try to make sure we're not only adding value, but the charge for our service is kind of commensurate with the overall value of the estate. That's not to say we charge a percentage of the estate. You'll still pay us hourly, but you know, the work that we do for a $20,000 estate is likely much different than the work we need to do for a $2 million or $20 million estate. And so the cost benefit of who does what, and the allocation of responsibility can differ depending on the estate circumstance. And as we were talking about earlier, if the estate is insolvent, even if the decedent died with a will who nominated an executor, that executor is basically working for the benefit of the creditors, which I find often takes away some of the willingness of the executor to serve. You know, why does the executor want to work to do all this stuff just to pay all the money to the creditors, whether they're an heir of the estate or not? In those situations, often the administrator is one of the creditors. So there are a lot of issues that we've only had opportunity to touch on. We're happy to help advise, coach, or assist in any estate administration on all of these distribution issues that might come up. Sarah, do we have any other questions?
No, sir.
Great. Well, thanks everyone for joining either live or if you link and join later. We hope this information is helpful, but if not, or if you have a different situation, feel free to call any one of the three of us. We're happy to answer questions. Oftentimes just over the phone, it takes a few minutes to get you pointed in the right direction, and we're happy to do that. And of course, we're happy to assist with any administrative situations that you're facing. So feel free to contact us. Thank you for joining us. Enjoy the rest of the rainy day, at least here in Washington, and check in again in December when we'll be talking a little bit more about how to resolve disputes when they arise. You know, the probate process and the non-probate administration process is not what contributes to the significant time or costs incurred in the administrative process. It's the fighting. It's the method of dispute resolution. It's the effort needed to resolve disputes, whether they be over who's in charge of the estate or who owns the estate assets, or with a creditor, or amongst the heirs and beneficiaries. It's the fighting at each of those levels that costs the time and the money that you've all heard horror stories about. So next time, join us and we'll talk about some of the methods and basic principles associated with resolving those disputes. Thank you, everyone.